Right now, there are people sitting in jail cells who were never guilty of anything. They were not arrested because of evidence. They were not arrested because of a warrant. They were arrested because a police officer asked them one question, and they answered it. And the terrifying part is this: every single one of those people thought they were helping themselves. They thought being polite, being honest, being cooperative would make the officer see they had nothing to hide and let them go. Instead, every word out of their mouth became a brick in the case built against them. I have studied this for years. I have reviewed the interrogation transcripts, the body cam footage, the suppression hearings, and the courtroom records. And what I found is that police officers are not winging it. They are running a playbook. A structured, legally refined, psychologically engineered playbook, and most people walk straight into every single trap on it without ever realizing what just happened. Tonight I am pulling that playbook apart, trick by trick. Not just the traffic stop tactics, but the search tactics, the detention tactics, the at-your-door tactics, and the interrogation room tactics that most people never see coming because they only ever heard about the traffic stop version. Every trap exposed. Every counter-response backed by constitutional law and Supreme Court precedent. This is educational content to help you understand your constitutional rights. For advice specific to your situation, always consult a licensed attorney in your state. And if this channel is new to you, subscribe right now, because this video is one piece of a complete library being built here. That scenario has its own specific legal framework, and knowing the difference between these situations is what separates the people who walk away from the people who do not. The first trick starts before the officer even says a word about the real reason he pulled you over. It is called a pretext stop. In Wren v. United States, the Supreme Court ruled in 1996 that a traffic stop is constitutionally valid whenever an officer has probable cause to believe any traffic violation occurred, even if the actual reason he stopped you has nothing to do with that violation. A broken tail light. A rolling stop. A lane change without a signal. These are not mistakes the officer noticed. These are entry points. The officer who is interested in you for something else entirely can use any minor infraction to legally stop your vehicle, open the encounter, and begin building toward whatever he was actually looking for. And here is why this matters before anything else. Because the moment you believe the stop is just about the tail light, you relax. You become friendly and forthcoming. You answer questions freely because you have nothing to hide about a broken tail light. And that is exactly what the pretext stop is designed to produce. The minor violation is not the point. Your behavior after the stop is the point. The second trick is the very first question out of the officer's mouth almost every single time. Do you know why I pulled you over? Most people hear that as a formality. It is not. It is an invitation to confess. Because the natural human response to that question is to guess. Was I speeding? Did I roll through that stop sign? And the moment you say that, the officer no longer has to prove the violation. You have done it for him. You have handed him an admission before he has shown you a single piece of evidence. Under Birkmeyer v. McCarty, the Supreme Court ruled in 1984 that roadside questioning during a routine traffic stop does not constitute custodial interrogation for Miranda purposes. That means the officer can ask you questions, your answers can be used against you in court, and he has no obligation to read you your rights before doing it. You have no Miranda protection standing at the side of that road. The correct answer to, "Do you know why I pulled you over?" is simple and complete. No, I don't. Polite. Calm. Nothing added. You have answered the question without giving the officer a single usable word. The third trick follows almost immediately. Where are you coming from? Where are you headed? This sounds like conversation. It is not conversation. It is the construction of a timeline. Whatever you say, a bar, a friend's house, a party, a restaurant, becomes information the officer can test against other things he is fishing for. It becomes the foundation of follow-up questions. It puts you in a location at a specific time in a way that can be used against you before you understand where the questioning is going. You are not required to narrate your evening to a police officer. When he asks where you are coming from or where you are going, you look at him calmly and say, "Officer, with all due respect, I will not be answering that question." Not rude, not aggressive, but firm and final. The fourth trick comes the moment the officer senses you are not going to simply hand him everything he needs through conversation. He tells you to step out of the car. Many people believe they can refuse this. They cannot. Under Pennsylvania v. Mims, the Supreme Court ruled that an officer can order you out of your vehicle during any lawful traffic stop, in the name of officer safety, without needing any additional suspicion of a crime. Refusing that order can result in being physically removed from the vehicle and charged with resisting. But stepping out is not the same as surrendering. The moment your feet hit the pavement, you say, "Officer, I do not consent to any searches. Am I free to leave?" You have complied with the lawful order. You have simultaneously put your Fourth Amendment refusal on camera. And you have asked the question that starts the constitutional clock. The officer must now either let you go or articulate a reason to hold you. Every minute that passes after you ask that question is a minute the officer must legally justify. The fifth trick is the most common search trap of all. "Mind if I take a look?" 3 words, said casually, as if the answer is obviously yes. In Schneckloth v. Bustamante and United States v. Drayton, the Supreme Court held that voluntary consent is a valid exception to the warrant requirement, and that officers are not required to tell you that you have the right to refuse. They can ask. You can say no. And they are legally prohibited from informing you of that right before asking. Once you say yes, that consent is on the record and nearly impossible to challenge later in court. A woman in Arizona consented to a search during a traffic stop in 2018. Officers found 55 pounds of marijuana in her trunk. Because she gave voluntary consent, that evidence was fully admissible. A single casual yes handed prosecutors everything they needed. The response to, "Mind if I take a look?" is the same every time, delivered calmly, without hesitation. "Officer, I do not consent to any searches." Say it clearly. Say it on camera. And do not add anything else. The sixth trick is the command that is not a command. "Pop the trunk." No question. No request. Pure authority. Officers are trained to speak in authoritative tones specifically to trigger automatic compliance, the same instinct that makes you stop at a red light without thinking. They are counting on you to comply before your brain has time to process that this is not a lawful order, it is a request dressed up as a command. And if you comply voluntarily, even under pressure, courts will treat that as consent. The response is the same. "Officer, I do not consent to a search." You are not being uncooperative. You are exercising the Fourth Amendment right that the Supreme Court has explicitly confirmed exists in this exact situation. The seventh trick arrives when you have not fallen for any of the first 6. The officer leans in and says, "I think I smell weed," or "There might be alcohol in here." This is the odor claim, and it functions as an attempt to manufacture probable cause from nothing you have given him voluntarily. Courts have been shifting on this. The Illinois Supreme Court has ruled that the smell of marijuana alone is not sufficient probable cause for a vehicle search in a state where cannabis possession can be lawful, because odor does not automatically establish a crime. Similar rulings have come down in Colorado, Ohio, and other states where legalization has changed the legal equation. But regardless of what state you are in, the response is the same. "Officer, I do not consent to a search." You do not argue about whether he actually smells anything. You do not explain. You do not engage with the claim at all. You state your position and let the law do its job in a courtroom if it comes to that. The eighth trick is the warrant threat. You are going to make me get a warrant for this. Sometimes this is real. Most of the time, it is a bluff designed to make you surrender your rights before the officer has to go through the work of actually obtaining one. Either way, your response does not change. If he wants a warrant, he can get one. Until he has one, the answer is, "Officer, I do not consent to a search." But the warrant trick has a cousin that is even more manipulative, the false warrant claim, where the officer tells you he already has a warrant. Under Bumper v. North Carolina, the Supreme Court ruled explicitly that consent obtained after an officer falsely claims to have a warrant is not voluntary consent. It is submission to false authority. It does not count. If an officer tells you he already has a warrant, your response is, "Officer, I would like to see the warrant." A real warrant will be produced. A bluff will evaporate. The ninth trick targets your body rather than your car. I just need to do a quick pat-down for my safety. Under Terry v. Ohio, an officer can only conduct a pat-down frisk if he has reasonable articulable suspicion that you are armed and dangerous. That is a specific legal standard, not a vague feeling, not a precaution, not standard protocol. He needs a specific reason to believe you have a weapon. But officers know that many people will consent to a pat-down simply because they were asked, which eliminates any need for the officer to establish that standard. If you consent, your ability to challenge the search later is severely limited. Your response is, "Officer, I do not consent to a search." And understand that the legal authority under Terry only extends to the outer surface of your clothing. If an officer's hands go further than that without your consent, and without legal justification, that is a Fourth Amendment violation, and it is exactly the kind of documented conduct that suppression hearings are built on. The 10th trick is the K-9 delay, calling in a drug dog when you have not given the officer anything he needs voluntarily. Most courts have held that a dog sniffing around the exterior of a vehicle during a lawful stop does not constitute a search under the Fourth Amendment. But in Rodriguez v. United States, the Supreme Court drew a hard line. An officer cannot extend the duration of a traffic stop beyond the time needed to complete its original purpose just to wait for a drug dog to arrive. Officers know this, so they use delaying tactics to run out the clock. A slow walk around the vehicle, irrelevant questions, paperwork that takes longer than it should. Every few minutes you ask calmly, "Officer, am I free to go, or am I being detained?" Every time you ask, it goes on camera. Every time you ask, the clock is documented. You are building the record that makes a Rodriguez challenge possible. The 11th trick moves off the roadside entirely and comes to your front door. The knock and talk. An officer knocks, identifies himself, and says he is just going around the neighborhood asking a few questions. Under Florida v. Jardines, police have an implied license to approach your front door and knock. But that same case drew a hard line at the threshold. An officer cannot search the curtilage of your home without a warrant. Your backyard is not accessible. Your side yard is not accessible. And you are under no constitutional obligation to answer your front door, engage with the officer, or open it under any circumstances, unless he has a warrant. If he does have a warrant, he can show it to you through a window. If he does not, you are fully within your rights to stay inside, keep the door closed, and say through the door, "Officer, I do not consent to a search. Do you have a warrant?" The 12th trick is the welfare check. The officer claims he is there to check on your safety or someone inside. Under Caniglia v. Strom, the Supreme Court significantly narrowed the community caretaking exception, ruling that it does not automatically justify warrantless entry into a home. If officers arrive claiming a welfare check, go to the door, keep it closed, and speak through it or through a window. Officer, I am fine. There is no emergency here. I do not consent to any search or entry. Show yourself visually if possible so the officer can see you are unharmed. Remove the emergency justification before it can be invoked. The 13th trick takes place when you are out in public and an officer approaches you with what feels like a friendly conversation. Hey, we're not accusing you of anything. We just want to talk. This is what the law calls a consensual encounter. The most common misconception about it is devastating. People believe that because they have not been read their Miranda rights, the conversation is not an interrogation and cannot be used against them. That belief is completely wrong. Miranda rights only apply when you are in custody and subject to interrogation. A consensual encounter on a public street requires neither. Everything you say is fully admissible. The officer knows this. You are the only one in the conversation who does not. The moment an officer approaches you in public and begins asking questions, you respond. Officer, I exercise my right to remain silent. I will not answer any questions unless my attorney is present. Under Burgess v. Tompkins, simply staying silent is not enough. You must explicitly invoke your right out loud. And under Davis v. United States, officers can continue questioning you until you unambiguously ask for a lawyer. I think I might need a lawyer. Does not stop the questioning. I want an attorney. Does. Say it clearly. Say it once. And stop talking entirely. The 14th trick is the invitation to come to the station. If you come down and we can just talk this through, we can clear everything up. Clear everything up is interrogation room language for placing you in a controlled environment, outnumbered, without support, where officers intend to work until you produce a usable statement. Innocent people have confessed to crimes they did not commit in exactly this setting. Ted Bradford of Washington State sat in prison for over a decade after confessing to a crime he did not commit, because officers told him they had DNA evidence that did not exist. He explained himself in response to a lie, and the explanation became the conviction. If an officer invites you to the station, the answer is, I exercise my right to remain silent. I will not answer any questions without my attorney present. The 15th trick operates across all the others. The fact that police officers are legally permitted to lie to you. They can tell you a witness identified you when no witness exists. They can tell you your associate already confessed when no statement was ever made. They can make promises about your outcome that they have no authority to keep. Under Colorado v. Connolly, courts have permitted extraordinary latitude to police manipulation as long as it does not cross into outright coercion. None of those lies are illegal. And the response to every lie, every false promise, every manufactured urgency is identical. I exercise my right to remain silent. I do not consent to any searches. I will not answer questions without my attorney present. These are not the words of a guilty person. These are the words of every person who has ever walked out of a legal encounter with their rights intact. Memorize these before you close this video. No, I don't. In response to, do you know why I pulled you over? Officer, with all due respect, I will not be answering that question. In response to any question about your whereabouts or activities. Officer, I do not consent to any searches. Am I free to leave? The moment a search is suggested, implied, or ordered. Officer, I would like to see the warrant. In response to any warrant claim. Officer, I exercise my right to remain silent. I will not answer any questions without my attorney present. In any encounter on the road, at your door, or in public. I want an attorney. The moment you are placed under arrest or told you are being detained. Say it clearly. Say it once. Stop talking completely. If this video reached you before your next encounter with law enforcement, it did exactly what it was built to do. Subscribe to this channel right now, because each one of these tricks has its own dedicated video with the exact words, the exact case law, and the exact constitutional framework specific to that scenario. The traffic stop, the smell of alcohol, the step out of the car order, the armed question. Each one goes deeper than what could be covered here, and every gap between them is a gap law enforcement is trained to exploit. Subscribe. Share this with someone who does not know what they do not know yet. Someone watching this tonight might walk into one of these traps tomorrow, not because they are guilty, not because they are careless, but simply because nobody ever told them the playbook existed. Now they know. Stay calm. Stay silent. Stay protected.